Well, hello, creators. It's great to hang out with you guys again for another Video Creators Podcast episode. My name is Tim Schmoyer, and in case we haven't hung out before, this podcast is all about helping you guys grow your YouTube audience so you can spread a message that reaches people and changes their life. And today, I want to talk with you guys with a friend of mine, Mr. Jeremy from J House Vlogs. He's also an attorney. Tell us a little bit about your channel, your journey to YouTube.
Well, I wanted to be a filmmaker initially when I was in college, and I worked at a motion picture studio and saw that I had to be a small cog in a big system.
Mm-hmm.
So I said, I'm not going to do that. It's not going to work with my family. Went to law school, became a lawyer. I was a trial attorney. And then I found family vlogging on YouTube. And I was like, we could do this. So I started a family vlog 2.5 years ago, and we're family vloggers now.
Full
That's what we
time?
do.
You quit
Yeah.
the law firm, kind of?
I left what I was doing at my other law firm. I now
Yeah.
started a new law firm representing YouTubers.
Right.
Me and my brother have partnered up. And
Yeah.
so, yeah, we are doing YouTube and legal stuff for YouTubers.
Yeah, that's awesome. So what we want to talk with you guys about here today is the contract negotiations you guys do with brand deals and some of the terms that are in those brand deals that are like really confusing. I know a lot of creators will just kind of like blindly just like, oh yeah, you're going to give me money? Sure. What do I have to sign for that? Right. And they end up signing things that they shouldn't have signed, or they find out later, they're like, wait, you can't do that. And they're like, yes, we can. You sign it, and there's been many stories of creators that have gotten screwed because of this, and not screwed. It wasn't their fault necessarily. Well, it was their fault. It wasn't the brand's fault that they got screwed. It was like the creator agreed to it. They just didn't know what they were agreeing to. So we want to talk with you guys about today are some of these common terms that you need to know that are a part of these contracts, and give you guys some examples and things so you kind of have an idea when you read these, kind of what you're looking at, what they mean, and more importantly, what they don't mean. Now, just before we jump into this, a piece of advice that I got early on that was really helpful for me is, Tim, always consult with an attorney before you sign anything, even if you think you understand it all.
Yeah.
Is that advice that you give? I mean, I guess I'm asking the attorney that, but
Yeah. The reason why I think that is good advice is because contracts are written in legalese.
Mm-hmm.
They're not, the words don't necessarily mean what you think they mean, because it's dependent on what a judge has interpreted those words to mean.
Right.
And you aren't going to understand that if you haven't been trained or read the cases. So typically when I'm looking at a clause, I also know how a judge has interpreted those words and what they mean, and then you apply it to the different circumstances. And so without the expertise of seeing a lot of circumstances and how those words apply, you can't know exactly what it means. It's like getting a document in Spanish. You can look up word for word what it's saying.
Google Translate.
But you're going to be much better off getting someone who speaks Spanish to
Right.
help you understand what you're doing. That's how it is with a contract.
Yeah. So the first one that I hired an attorney to do, I forget what the arrangement with the deal was. It was a long time ago, but it was a very low paying gig. I think it paid like $200-300 or something, and it cost me $250 to do the contract review with the lawyer. But I was like, well, I'm not gonna make any money on this. I'm gonna chalk this up to a learning experience. So I hired the attorney. Who's a copyright trademark lawyer, and this is the early days of YouTube, so there weren't like YouTube lawyers like yourself around at that point. And he's still the lawyer I work with today. He's a great guy, very good teacher I found, and that's why I like working with him now. But I paid him like almost everything I made to go through the contract with me, and it was the most valuable experience I've had on the legal side of this stuff.
Yeah.
Because what he did is he went through it with me, and he explained to me this is what this means, because sometimes like I knew what that like the clause meant, but there's like inferences of things that it could also mean, or what was more important were the things that weren't in there that should have been in there. And he said, Tim, you should add these things or request that this gets added or this gets specified, things that I otherwise would have no idea was something I should have like considered. So I found it extremely valuable, and I give everyone that same advice now. Even if you're going to lose money on the deal, just for a little learning experience alone, do it, but you'll also end up better in the end. And so now, like I turned down 2 weeks ago, a paid gig that was going to pay about 3 times more than we normally charge. They kept upping the price because I kept saying no, because it had this little clause, and maybe we'll get into this, in perpetuity. Is that how you say that word?
In perpetuity.
And I was like, I'm not selling you anything forever and ever and ever, So I said no to it because of that clause. So Gonna be some really valuable stuff here. So what we're gonna do is we have a sheet from us from the Internet Creators Guild in front of us. I'll put this in the show notes of the podcast episode, or for those who might be watching the video, in the description below. That'll go directly to this document. And what they did is a great job. And you actually helped them put this together, right?
Yeah, Laura Trinikoff over at the ICG reached out to me, and I sent her some emails, and we had a phone call where she asked about a lot of these specific things. And they met with a lot of different lawyers and put together a document laying out the basics of some contracts related to creators.
Yeah. And so we're going to read some of these clauses to you. I will do my best as a non-lawyer person to read them. And Jeremy's probably going to have to tell me how to pronounce all these words correctly. And then he's going to share with you guys what they actually mean in normal language, and then give us maybe some examples of what that looks like.
You can read the document, and that's helpful. What I want to add beyond the document is give it color. I want to give examples so that you can really visualize it and see what circumstances it would apply in, because that helps you understand it better.
Yeah.
The other thing Thanks. The other thing that I should say as well is I'm not giving legal advice to any individuals with this. I'm just giving general principles related to the clauses of the contracts.
Right. Absolutely. And if you do want legal advice, though, that is a thing that you do.
Yes.
And there'll be a link in the show notes or in the description of this video. Wherever you're watching this, they'll go over to his YouTube law firm's practice, and you guys can find out more about him and work with him over there if you'd like.
Yeah.
So, not sponsored. I didn't even sign anything to say that. So let's go over this first clause, moral clauses. All right, let me read to you guys what this says. Creator agrees that during the term, he or she will not create any content that brings the agency or client into public disrepute, contempt, scandal, or ridicule, or which might tend to injure the success of the agency, client, or the campaign. Does that just basically mean be nice to us? Or
It means your image impacts your endorsement. So, for example, Tiger Woods, he was making hundreds of millions of dollars. Nike, Gillette, AT&T, FedEx were paying him to be a spokesperson or to endorse their brand. But then when news broke about all of the infidelities, that impacted the image he had, and the brands were nervous about being tied to that. So that would be an application of the moral clause of saying, look, we're severing ties. We want to break this deal. We're not going to pay you $100 million because your image has changed because of the decisions you made. There's some kind of scandal involved here.
Okay.
What's hard with these clauses is how do you define a scandal? How do you know what that is? So if you have a morals clause in your contract, you want to make sure that it's spelled out. You could say, look, only if crimes are committed or in specific circumstances would this apply. Otherwise, it's just left to the brand to determine, well, we don't like that you said something religious, and so we're going to completely, get away from you and have nothing to do with you because you spoke about your religion on your vlog, and you wouldn't want that to apply.
Sure.
So you have to try to define it as best as possible so you don't give them too much power.
So what advice for creators? Is that a pretty typical way of putting it that just makes sense, or is there anything else that they should add to that or anything? Or is that
all of the clauses in here aren't necessarily boilerplate in this document. Okay. And so they all can look different, and you can always come in and ask for something to be more specific. So as an attorney, if I was looking at this clause, I could say that I want it to be more specific what a scandal is so that it's not just left to your interpretation.
Right. And if you guys hear lots of rain in the background, it's raining right now.
Yes.
It's windy. But we're doing this because we want to help you guys. So
and we're glad to have you. Tim and his family are here at my house. This is our backyard.
We're recording on his back deck in the rain. All the kids are allowed inside, so this is the quietest place we could find.
Yeah.
It's awesome. All right, so then another one then is in indemnities. To the fullest extent permitted by the law, that sounds serious, creator will defend, indemnify, and hold harmless brand from against any... That's like brand, just fill in the brand there, I guess. From and against any and all claims, damages, losses, and expenses, including reasonable attorney's fees, to the extent arising out of the relating to any legal action brought or threatened to be brought as a result of creator's violation of law or breach of this agreement, including any of the representatives or warranties contained herein. Who learns to talk like this?
It's after years of a judge approving something, and then, back in the 1800s, this clause got approved, so then lawyers keep using it over time.
Okay. Yeah.
I think that the indemnities clause is the most intimidating. It's the hardest to understand, and this is actually really well written. Normally, it's much more intimidating than this clause, because where they put the word brand, you will hold harmless brand. That typically is a whole paragraph where it says, the company AT&T and its assigns, its partners, its owners, its representatives, and they'll have all of these descriptions of the brand. So it's a really intimidating clause. Let's break it down.
Yeah, what does it mean? What am I going to get in trouble for here?
What it is saying is that if you were working with AT&T and AT&T gets sued because of something you did related to the deal, they can come after you for the attorney's fees and the lawsuit if they were to lose or have a settlement or something. That's what they're trying to do. So let me give you some examples. Typically, this applies...
Sounds scary.
Yeah. Typically, these apply a lot in construction law type cases. So if I was building a house as a contractor and I had a guy who I brought in to pour the concrete, but then the foundation was terrible and the homeowner sued me as the contractor, any of the expenses I had for the lawsuit and for fixing the problem, I could go back to the concrete guy and say, hey, we had the Indemnities Clause. You have to cover this. And typically it would then be his insurance that would cover it. So the Indemnities Clause is all about shifting risk related to any project or anything you're working on.
So as a creator, do I need to have insurance?
It's not a bad idea the bigger you get to have a general clause, a general umbrella policy to protect yourself. I think that is always a good idea.
What would that kind of insurance be called if we were going to go shopping for it?
I think it's just a general policy, a business policy that's an umbrella that covers a lot of different things.
Okay.
Let me give you some examples, though, of how this could apply as a creator, because it's harder to see how this would look. Mm-hmm. Let's say that you were filming in a shoot for Tesla. You were doing a brand deal with them, and you're driving a Tesla, and you lose control of the vehicle, and you drive into a bakery and cause a lot of damage.
Yeah.
Likely the bakery would sue Tesla. But then Tesla could pull their contract out and say, hey, you're indemnified. We want you to cover the cost for this because you caused the accident. Okay. That's just an example of how it could apply.
Yeah, okay. So whoever has the damage done to is going to go after whoever has the most money.
That's right.
Which is probably going to be the brand, not us, you know, which is kind of nice. But then the brand's going to be like, no, it wasn't our fault. Sue him instead.
Well, no, they'll say you can sue us, but then we're going to make him pay for all of it after the fact.
Oh, I see.
So you have to then pay for the attorney's fees. You have to pay for the judgment if it was against you, or they could bring you into the lawsuit as well.
Okay.
So there's different ways it could work, but it's a way, again, to move that risk. And so what you want to do is in the agreement, you want to ask that the indemnities go both ways. Because there are situations where you could maybe be sued for something that happened, and you would want to make sure that you're protected as well.
So that would be something to negotiate, make sure it goes both ways in there.
Yep.
How important is it, in your opinion, for a creator to have insurance before they do brand deals? And again, this isn't legal advice. I understand that. Just like is it generally speaking, yes, you should, or because I don't know if I do or not. I don't think I do.
I didn't initially get it. Typically when you get insurance, it's when you have a collateral, like a house that could be damaged by a tornado, or you have, as a lawyer, I have legal malpractice because that's something that happens regularly. So as creators, it's not typically a lot of situations. There's not a lot of risk that you're going to be sued. I had to really struggle to think of examples where this would apply.
Okay.
And so
well, that's good.
The risk is much lower, but it's always safer to have insurance. But it's not something we jumped into getting when we were just doing YouTube.
Yeah. Okay. What's the next one here on the list? Assignment. So this says, Company A may assign or otherwise transfer any of its rights and interests or obligations hereunder, including without limitation, pursuant to a merger or consolidation without the prior written consent of creator. However, creator may not assign or otherwise transfer any of her rights and interests or obligations hereunder without the prior written consent of Company A. Any attempt by creator to assign or otherwise transfer any portion of this agreement in violation of this section shall be null and void.
Yay. For legalese.
Yeah. Okay. I was going to try to take a guess at this part, but like you have to do what we tell you to in this contract?
No.
Okay.
What this is saying is that you and I have a contract. So let's give examples to it. Let's give color to this.
Okay.
Let's say that you're signed with Maker Studios as your MCN, and you've entered into all these different clauses with them. If Maker wanted to join with Disney, if Disney bought out Maker, or they changed ownership, or they, sold out to another company, that your contract with them carries over to the other company. So they've assigned that contract over. Maybe another example that's more easy to understand is if you're an NFL player and you have a contract with the Patriots, you're Tom Brady, you're with the Patriots, your contract can be assigned. They can trade you, and now you're working for the Dallas Cowboys. That would be good for the Cowboys, right?
Yeah, that one might actually happen. But the Maker Studios thing totally did.
That happened.
Yeah, and all those everyone who was signed with that MCN is now transferred to.
They kept the
Disney.
same name, but Disney now has ownership, and
Right.
those contracts go along. So one of the things they say you want to do is make sure that the obligation of whoever is getting the assignment. So, for example, Disney, we want to make sure that they still have to pay us our percentage. And so you just want to make sure that you're protected if a transfer were to happen or a merger or something like that.
Okay, cool. Governing law is the next one. This is a short one. This agreement shall be governed by and construed in accordance with the internal laws of the state of California.
That one's more straightforward.
Yeah,
There's a lot to this, though, of importance. The thing that I didn't understand before I went to law school is every state has different laws. I thought it was all the same. You know, there's the law and it just applies. But because each state has its own set of laws, its own legislature, its own judges, laws mean different things, and there are different laws in different states. So it's totally different to handle a contract case in Kansas as it is in Missouri, even though they're right across the river from each other, because they have different implications. And so this is saying this is going to be governed in California. Other clauses that typically go along with the governing law is the jurisdiction. It could say if you're going to file suit, it has to be in California. And that's how it is with YouTube. Like if you wanted to sue YouTube, they say in there, you have to file it in this jurisdiction or it has to be in this venue. And so, you know, I recently entered into a deal where I was working with an MCN that was located out of the United States.
Oh, really?
And so they were saying Canada law applied, you know? And so those are things that you have to look at is what law applies and how does that impact the deal.
Okay, so is state of California, is that pretty typical with YouTube contracts?
Yeah,
If
New
you got in
York,
LA?
New York or California is often what you're going to find. And so it means if you were going to have to litigate, even for me as an attorney, I'm not licensed in California, but I could go to my friends in California and they could walk me into court and we could litigate the case there.
Okay, interesting. All right, next one, entire agreement. All understandings and agreements, if any, hereto existing between the parties regarding the subject matter hereof are merged into this agreement, including the schedules, exhibits, and other agreements referenced herein, which fully and completely express the agreement of the parties with respect to such subject matter. Any prior agreements or understandings, written or oral, regarding the subject matter hereof, and hereby superseded and of no further force or effect. I think my audience retention just went down.
Yeah, reading these clauses is hard when you can't see it.
Yeah, so entire agreement, what should we be considering here?
When you're beginning to negotiate any deal, it starts off as an oral agreement, or that's the beginnings of it. You have emails back and forth that talk about what is going to be in there or not be in there. And what this clause is saying is that we're going to completely disregard all of our emails or any conversations. All that is represented of our deal is now what's in the actual contract.
Okay.
And the reason that you got to be careful is that 50% of the time when I'm working with brands, I say, we are not going to have a licensing clause in this, which we haven't talked about yet, but I'm not going to let you use my footage for anything else.
Right.
But 50% of the time when I get the first draft, there's a licensing clause in there. And if I wasn't familiar with that and knew what it was, and I signed that, I could be showing up in perpetuity, you know, through all time on a commercial. And I could say, how did you get that? Or why are you using that? You don't have rights. And they could say, no, in the agreement that you signed, you gave us the right to do that.
Right.
And I would say, no, look at the emails. The emails say that I'm not going to do that. And this clause would say, no, we don't look to the emails. That doesn't matter at all.
Yeah, so this comes up a lot with a lot of creators who are thinking about signing with an MCN. I think it used to happen more, fortunately, than it does now, where the MCN's like, oh yeah, we're gonna give you all this all this education, all these brand deals we're gonna send your way. You're gonna make more money. You're gonna get a higher CPM. We're gonna like work with you to join your channel. Blah blah blah. And the creator's like, oh, that sounds good. Where do I sign? And they sign, and then the contract is like has none of that in there.
Nothing specific.
Right, and the way they like work with the channel is like they send you like a one sheet of like top 10 tips, like have better thumbnails, like just super generic stuff, and you're like, wait, what? Like what happened? And it doesn't matter because like that was said in conversations to get people to sign, and now it's not being delivered. And those creators are kind of left like they signed it. There's not much they can do about it at this point. So, which is another reason why it's really important that you work with a lawyer before you sign contracts like that. Next one is independent counsel. Each of the parties has had the opportunity to consult with its own legal counsel and other advisors and are entering into this agreement voluntarily and with a full understanding of the meaning and legal effects of each provision contained in this agreement. The parties and their respective legal counsel, if applicable, have been involved in the negotiation and drafting of this agreement. So that means, like, hey, you can talk to other people about this if you need to before you sign it?
They don't want you to be able to come back later and say, I didn't know what was in here. You're agreeing that you had the chance to go to a lawyer, you had the chance to understand it, and you're signing this voluntarily.
Right.
So after the fact, you can't go and say, I didn't know what I was signing. That's not going to work.
Okay. All right. Well, that's pretty straightforward then.
Yeah.
So the next few here, the next one is specific to brand deal agreements, FTC Guidelines. And this is just a sample one here. Wait, where'd it go? It's just this one little paragraph here, right? Yep. Contractor will comply with all applicable Federal Trade Commission FTC guidelines, which include the FTC's revised endorsement guides included as a schedule in this agreement. This is something a lot of creators don't consider, the FTC guidelines. This is specifically for the U.S. Creators. I mean, every country might have their own stuff going on with this, but what are the FTC guidelines they're referring to here?
The FTC wants us to be giving an honest endorsement. They want it to be clear that we are being sponsored. So they don't want you to be eating Cheerios and putting it out there for kids to see or people to see without giving proper... They don't want us to be tricking people in any way or misleading. That's really what their concern is. And so you say, I am being sponsored by Cheerios, so that people know and that it's honest that part of the reason why I'm eating Cheerios is because I'm getting I'm monetizing this. I'm being paid to do this.
Right. So this happened, I don't know, several years ago now at this point, where a lot of mommy bloggers, I think is where it kind of like pushed it over the threshold for the government to make this decision, is they were writing about things that they were getting paid to write about and not disclosing that this was paid.
Yeah.
And it just made like their opinion and their voice kind of like clouded to their subscriber base and the consumers who weren't sure, like, are you talking about this because you genuinely like it, or are you actually just getting paid to write about it? And created a lot of confusion, a lot of issues. And so the FTC stepped in and said, no, if you're getting compensated in any way, full disclosure is absolutely necessary. And in terms of YouTube video, preferably towards the beginning of the video. So like what I do is I always say, like, do the little intro and then welcome them and say, like, we're going to talk about this, and thanks to our sponsors at, such and such, or people over at such and such website were like cool enough to sponsor this episode. For example, this episode is sponsored by graphicstock.com/creators. If you guys want some like great stock footage that you can use, like thumbnails for your thumbnails and images and stuff, like you just can't go to Google Images and just take anything that's there, because a lot of those images could be copyrighted, right? Yeah. So if you want stock royalty-free images that you can use without getting in trouble in your videos, I go to like a royalty-free site like graphicstock.com/creators. And so you can find a link in the show notes or description here. I'll go over there and give you 7 days for free to download as much as you want, to use as many things as you want without any of these types of issues. So you can check that out if you'd like. So thanks to those people for sponsoring this. But I didn't just say, like, I use GraphicStock. I said I let you know this is sponsored by them, and so now you know, like, the terms of my agreement, my
you have an incentive to say that you're using them. This is actually one of the terms that I have to negotiate a lot, because brands and MCNs often have their own language that they want you to use, and a lot of times I don't like that language because it's too commercially. Mm-hmm. Like, I don't, one time I was in a deal where they said you have to say, this entire video is blah, blah, blah. Like, they had a sentence they wanted me to say, and I was like, that's not the FTC guidelines. Make sure that you go to the source. The FTC has a website and a frequently asked questions related to creators for YouTube, and you can see what is required there, and you really do need to be familiar with it, because you also can be in trouble with the FTC outside of this contract. Like, you're actually bound to follow their guidelines, or
Right.
you could
Without
receive
citing
a fine.
anything.
Yeah, it's
Yeah.
possible to receive a fine. So this is an area you want to be familiar with and that you might need to negotiate. And I've often gone back and forth with attorneys and said, here's what the FTC website says. You're asking me to do this, and what you're asking is more than what the FTC requires, and we're not comfortable with that because it sounds too much like a commercial. We want it
Right.
to be really authentic.
Right.
So we're going to say this and do this, and that should be in line. Are you okay with that? And that's how a negotiation would go back and forth
Right.
about it.
Cool. And when you hire an attorney, they can do that negotiation for you, and so you don't have to be the bad guy necessarily, which is awesome.
I want to insert here real quick.
Yeah.
You know, they have the heading here of brand agreements, and the FTC was the only unique, heading that they put in. I think that there's a couple other clauses that really should be
Sure.
talked about here.
Yeah.
And they don't have in this article about exclusivity. And that's
yeah.
one of the most important clauses. Exclusivity is where you're saying, I'm only going to endorse this area of product. So, for example, if you're working with Target, I'm not going to do any retail stores for 3 months from the time that this video is posted. That's
Right.
often an exclusivity clause.
Right.
And so that's one of the most regularly negotiated clauses in a brand deal, is how long that exclusivity is and how broad it is. You want it to be as narrow as possible. So you want it to be like, if we were doing Babies R Us, like I'm only going to do retailers that focus on babies, so I could do Target or Walmart if I wanted to, but you can really get yourself in trouble and have really long exclusivity clauses, and that makes the deal much more painful because it limits you from doing other deals.
Or potentially more valuable. You can
Sure.
charge more. Like, so you can agree to that, but it's going to be more money
Yeah.
for you because you're going to have to turn down these other deals that you could have otherwise have done.
Yep.
So just, so you can use it, just
Yeah.
you can pay for it. That's all.
Yeah.
Anything else in the brand deal?
Yeah,
agreements?
another one is the licensing deal. That's
Oh,
not
yeah.
in here, but typically in a brand deal, they may say, we also want to license some of this footage to put on our website. You're working with Mattel, let's just say as an example, and you're doing a video about it, and they say, we want to use that little segment on our YouTube channel, or we're going to put it up on a commercial, or we're going to do this or that. If there's a licensing clause in that brand agreement that says they have worldwide, non-exclusive
Right,
rights to do
exactly.
whatever they want in perpetuity
Right.
forever.
That's what my contract that said no to had.
Yeah.
Yeah.
So they forever could use your stuff. You want to make sure to catch that and not allow the license. And typically our brand deals are for no license because that would be an added value that you would need to include in.
Yeah. And I didn't so for example, the reason I said no is like, well, one, I'd have no idea what the future holds for us and our family. So let's say, for example, I'm just gonna make up like a case scenario. Let's say our channel blows up and we end up on some television show, and now we're no longer doing YouTube, but we're like let's say television stars. I'm not trying to go that direction,
Yeah.
but just say that happened. Now that brand,
25 kids and counting.
Yeah,
Your
there
new
you go.
show.
we're up to 7. Think we're gonna.
I'm just kidding.
Yeah. So we anyway, that's a whole other story. But so they could have in that case continued to use the content we made for that arrangement over and over and over again, even though at that time, let's say we would be worth like $1 million deal, and they got it for like $1,000 or something. I was like, no perpetuity stuff worldwide. You can use it for whatever you want, type stuff. And they were not willing to negotiate that. So I said, well, then there's no contract, So we just didn't do that.
So the one other thing I would want to say that you should be aware of with brand deals is that often they're using old contracts. And a lot of times the people sending you the contracts aren't lawyers. And so there will be clauses in there or things that are outdated. So I often see it where they say, you will use an annotation on YouTube.
Oh.
And it's like, we don't use
Why?
annotations. So
Yeah.
you need to make sure they know. I mean, we could include an end screen or we could use iCards, And so a lot of times the thing that they're requesting isn't possible, or they want me to link to their website as an iCard. And
Right,
it's like,
you
well,
can't.
I can't do that.
Right.
And so you really want to read that stuff and respond with the up-to-date information of what you can and can't do on YouTube. That's
Yeah.
a very common problem.
In that case, you technically can't do it. If you're wondering why can't you do that, you technically, unless they give you link their domain to your webmaster tools and you change it,
Yeah.
it's possible, but that kind of gets into some gray, if not black area
Sure.
in the TOS as terms of service as far as YouTube is concerned.
Yep.
So, don't do that.
Okay, one other thing I want to talk about. This is outside of brand deals, but it's a whole area of contracts that's not included in this document.
Okay.
Is partnership agreements. A lot of times you, as a YouTuber, might be working with someone else, or 5 people come together to start a channel. And say that as you're going along, one of you decides to quit. They don't want to do it anymore. But then 3 months later, the channel blows off and it's making millions of dollars.
Yeah.
That 5th person could come back and say, I want my 20%. And if you didn't have a contract, there is a binding contract. Every state has partnership law. And if you don't have anything written down, there is an oral agreement there, and they could go to the laws of the state, and you would have to buy them out potentially. And so if you are working with other people, you really should have a partnership agreement to protect how you get in and out of it and to define the relationship.
Yeah, you guys catching on like why it's important to do this stuff with a lawyer, not just be like, oh, yeah, it looks good, sign this stuff. Cool. Anything else on brand deal agreements, or you can go to MCN stuff?
Yeah, we can go to MCN.
All right, MCN deal agreements. Grant of rights. Creator hereby grants to MCN. Do I say the I's? How do you say that when you're reading this out loud as a lawyer?
I don't know. I would probably say one.
Okay,
one.
One, and a non-exclusive worldwide, non-transferable, royalty-free license to use this likeness, appearance, name, biographical information, logo, and trademarks on MCN's websites and social media platforms in connection with MCN's marketing, sales, promotion, and social media efforts. 2, the exclusive right to sell and represent any and all ad inventory on your channels. And 3, the exclusive right to sell sponsorship, brand integrations, or similar sales opportunities for your channels and any other digital and social media platforms that you own, control, or manage, subject to your written approval of each individual campaign. That's a little different than most I've seen, actually. This is a little bit more nicer.
Yeah.
Usually it's just like you don't get a say. We just get to do it. This is like, from what I understand, subject to your written approval.
Sure.
That seems like they're going to ask you each time, but that's nice.
Yeah, as it relates to that specifically.
Well, maybe I'm misunderstanding. So tell me what's going on here.
Okay, so essentially this is just laying out what you're giving to the MCN to join their MCN. And again, this is a multi-network MCN network. No, wait, I said it wrong.
No, MCN
multi-channel network.
Right, that's what
there we
it
go.
For. There you go.
That's embarrassing.
No, sorry.
All right, so the multi-channel network, and this is just saying that we're basically all coming together as a bunch of channels, and we're going to have advertising that's tailored to our channels that we work with. And so we're going to set up deals where we can run promos or ads on your videos, but we can also use the likenesses and the image of all these different channels to promote our MCN.
Mm-hmm.
And so you're giving the right for them to do that. And so they can use your image on Maker Studio. You could see Daily Bumps up there as an example.
Like at the booth at VidCon, like your face could be up there, and now
Sure.
you're like endorsing them, even if you hate them, I guess. But is that written approval thing? Does that mean that they have to ask you each time before they do it?
So number 3 is specifically talking about brand deals, where you're doing like a sponsored integration on your channel. And so they're not going to come and tell you have to do a brand that you're not interested in.
Right.
You have the approval of whether or not you're going to do a Gillette one or you want to work with a different shaving company.
Sure. Okay.
So that's where the approval is related to. But what they advertise on your channel, there isn't that. They get to decide what ads run before your video shows. That's part of what the MCN gets.
Right. Cool. All right, next one is about the term. The term of this agreement shall commence on December 1st, 2017, for example, and continue for a period of 24 months, the term, on parentheses, unless extended for an additional year upon mutual written agreement of the parties.
This is the place where you see the in perpetuity, where people could get into a term where it lasts forever. Yeah. And the MCNs want the term to be as long as possible. Typically, their model is they have a lot of salespeople who are really nice, who come to smaller channels and say that they can get 1,000 channels who have 1,000 subscribers to sign up. They know that eventually over 2 years or 5 years or however long the term is, some of those channels are going to blow up and become very wealthy. And as an MCN, they get a cut of that. So that's really their model, is they want to bring in as many channels as possible. They want the term to be as long as possible.
Right.
There's not a ton of benefit for you as a creator for it to be as long as possible. So when I'm negotiating a term, if I was doing this, I would want it to be as short as possible.
Right.
I mean, depending on if you really feel like you like the services. If you can say, I want to do 3 months of a trial run and see what you actually give me and what I do, because some MCNs are set up where they have a lot more salespeople than they have people giving any kind of service.
Right, exactly.
It's a lot of talk and a lot less actual providing help.
Right. Cool. Compensation is the next one. Revenue share. Subject to creators' compliance with the terms and conditions of this agreement, during the term, creators shall receive from MCN 80% of all MCN direct sold brand integrations, and B, 80% of all AdSense revenue, as well as any freemium or subscription fees on the creator channel. So this is kind of agreeing this is where you agree how much money you're going to, what your cut of the money is going to be that your channel generates?
Yeah, the money we make from our deals, from AdSense, or from YouTube Red, that would be like those subscription services. Mm-hmm. If we made $1 million on our channel, then you get $300,000 if it's a 70-30 split. That's what they get.
They better be, pulling their weight.
And that's why if you're making a contract with an MCN, what are they going to do to make it worth $300,000 of service? Mm-hmm. And so that's something that we haven't entered in with an MCN.
We haven't either.
Because every time I meet with them, I'm saying, what specifically are you going to do? And for me, if I wanted a consultation on the back end, I would hire Tim, and get a consultant. If I needed
legal, I don't
legal,
give you a contract. You can just walk away from that if you want to.
Exactly. So I'm going to pay the amount for that consultation, or I'm going to go to a lawyer directly if I need legal help, and I'll pay for that. But I'm not locked into what could be losing a lot of money for not getting a lot of service.
I don't charge $300,000 for a consultation.
Exactly.
So you would have made a lot of money on that one. Promotion. Creator will help promote MCN, its network, and its affiliate channels and talent through marketing, promotional activities, and regular social media platform posts as reasonably agreed to by the parties. Participate in relevant sponsorship, talent integration, and collaboration opportunities, including attending and include the MCN business inquiries email address and logo on all your channels.
I think, again, an example here helps explain what this clause is talking about.
Yeah, it sounds like I just need to promote them.
Yeah, any NFL player who's on the Patriots team, again, Tom Brady, there's going to be Patriots photo shoots or fan nights or events that they have to go to as being part of the team. Mm-hmm. And so it's the same kind of thing with the MCN, where it's just saying, we are allowed to use your likeness, and there's things you need to come to be a part of our group. And you're going to help promote us. Okay.
So, but this one is saying, like, you need to include, like, business inquiries, our email address and logo on your channels, in your descriptions, I'm guessing is what that means.
Yeah.
Like you have to funnel all your business inquiries through us.
Yeah, and in the paragraph below, they say you want to be careful that you really know exactly what you're agreeing to do. How many events are you going to be going to, or how much is your face going to be up? Those are things you want to make sure are defined.
So a good example of this, maybe, I think, on my mind, maybe not, but is we have some friends that were with an MCN, and this other brand came to them outside the MCN and said, we really want to do this deal with you. It's like a perfect match, but the brand didn't want to work through the MCN because it was like really convoluted and a lot more complicated. They just wanted to work directly with the creator. The creator really wanted to work directly with them, but the creator couldn't because it wasn't going through their MCN, and so the creator had to say no to that deal. Is that because of this type of clause?
No, that would be more related to exclusivity, like whether or not you have exclusively, I'm only going to do deals through our MCN, or non-exclusive. This is just saying promotion. We will promote the MCN. Yeah. Okay. So it's limited to that.
Gotcha. All right, and then the final one here, warranties and representation. Creator represents and warrants that, 1, you are at least 18 years of age or otherwise legally capable of entering into binding agreements such as this, and including this one. 2, you have the full right and power to make and perform this agreement without the consent of any third party. And 3, you have any and all necessary rights or clearances you may need in connection with your channels, and that your content will not infringe on the rights of any person or entity, defame or disparage any person or entity, or violate any right of publicity or privacy of any person or entity.
This is a final protection for an MCN or whoever you're entering into, is say, look, you are able to enter this agreement. Like if you were 17 years old, you can't enter binding contracts. Mm-hmm. So, and you have the rights and ownership of J-House. Say that I'm entering into it, but I didn't own J-House or somebody else did. Or if you're working with music people, it's like, well, the publisher owns some of the rights. Mm-hmm. And so, I have all the rights to enter this agreement, and I'm not violating any copyright with the content we did, where somebody else could come and say, look, you did a vlog integration, but you used Michael Jackson's music, and so he owns all of the rights to that video that you made.
Yeah, that would be bad. Just don't use copyrighted stuff in general if you can get away with it.
Sure.
Cool. Is there anything else we need to consider here? Does that cover most of it?
I think that covers most of it. Cool. We covered a lot of clauses. Yeah. There is a lot more. I mean...
That's why you hire someone.
Yeah, there's a lot more clauses that are out there. These are the most common ones that you're going to see that come up. And I talked about some of them that weren't in there, like licensing clause specifically or exclusivity. But the part that we didn't really talk about here is the negotiation side of the contract. As an attorney, each of these different clauses, the way they're written or what's expected, becomes a part of the negotiation. And understanding your value of what you're providing and how much more it costs if the exclusivity is longer, or if we give a licensing portion of this, how much more is that worth? That's the other place where having an attorney really makes a difference, because they can help you with the valuation of all the different aspects of the clauses.
And I really liked when I work with an attorney that he just takes care of that for me. Like he just does the negotiation. Or he's like, this is what it needs to include that's not in here. I'm like, oh, I'm not gonna be able to explain that. He's like, yeah, I'll I'll communicate it for you, make sure that they understand and everything. I'm like, oh, thank you so much. So definitely worth it. If they want to work with you guys, there's a link in the show notes to his website. You can work with Jeremy and his firm directly with any of your YouTube legal stuff. And if you want to check out his family, be at youtube.com/jhousevlogs, growing his channel over there with his cute kids and wife and family and everything. So you guys go check that out. And love to have you subscribe if this is your first time checking out the podcast here on iTunes, SoundCloud, or Stitcher. We got episodes for you every Tuesday just to guys help you grow your channel, make money, make it all sustainable so you can continue to serve the people that you care about online and who care about you, so you can impact and change their life with the message that you're spreading. So thank you for letting Jeremy and myself be a part of that. Subscribe, and we will catch up with you guys again next week for another Video Creators Podcast. See you then. Bye.